Hello, everyone, and welcome to Trademark Basics Learn the Fundamentals. I'm Jason Lott, the managing attorney for Trademarks Customer Outreach at the USPTO, and it is my job to teach you about trademarks, what they are, why they're important, and how the federal registration of your trademark can help you build your business. So in this afternoon's presentation, we're going to cover a lot of topics, and I'm going to move through them fairly quickly with a goal of being able to answer as many of your questions as I can at the end of the presentation. So the discussion topics that you see on the screen right there will probably take us somewhere around an hour, and hopefully we'll have about 20 to 30 minutes where I can do nothing but answer the questions that you might have. So one of the questions that people often have is this session being recorded and can I have a copy of the slides? And the answer to that is yes. Today's presentation is being recorded and you are more than welcome to have a copy of the slides. Our WebEx technician Ali is going to be popping a link to that in the chat. And so if you would like to download a copy of today's presentation, go ahead and open up the chat bubble. That's where Ali is going to be communicating with you today. And Ali will put the link to the slides in there, and he'll also put in a link to the captions. So if you want or need captions, we have a live captioner who's with us today. And so the link to live captioning will be in the chat there too. If you do have questions as we go through today, I am not going to be looking at the chat as I'm talking, but you can go ahead and pop your questions into the chat. And then when we get to the end of the presentation, I will pull up the chat and I will just start to scroll and try to answer as many questions as I can before we have to get out of here. So if you do have questions, please feel free. Go ahead and open up the chat and ask them there, but just be aware, I will not be looking at them. So if you're like, Jason, slow down, I'm not going to see it until the end, but I will do my best to not speed too quickly through the information. Just be aware, however, that I cannot provide legal advice. So if your question borders on or is asking for legal advice, I'm not going to be able to answer it for you. I will do my best to answer perhaps around the question to give you some general information so you can make your own choices. But if you're asking, is it okay if I do this, or should I do that? Should I do this? Those are the sorts of things that I cannot answer. So please forgive me if I'm not able to answer your question. And if there are a lot of questions in there, please also forgive me if I can't get to your question. I'm going to do my best to answer, though, as many as I can. All right, so to make sure we have enough time for questions, let's go ahead and dive into it. This is what we're going to be talking about over the next hour or so. We're going to talk about what in the world a trademark actually is. We're going to talk about the benefits of federal registration. So why does it matter to you as a brand owner? We're going to spend some time talking about how to select or choose or create a strong trademark. Then we're also going to talk about filing and registration. So what are the things that go into the application should you decide to file to federally register your trademark? Then I'm going to show you some resources, and then we're going to get into the Q&A. So let's dive in and talk about what in the world a trademark actually is. So as you can see on the screen, that is a fairly well-known logo. That, of course, is the Apple logo. And so the reason that I want you to take a peek at it is I want you to think about what product or service it is that you think of when you see that logo. No need to put it in the chat. You can just keep it to yourself or shout it out loud, depending on where you are. So what is the product or service that you think of when you see that Apple logo? For me, when I see it, boom, I automatically think about mobile phones, tablets, laptops, desktops, watches, earbuds, streaming services. So as soon as I see the Apple logo, I automatically think of very specific products and services. Same thing with Coca-Cola. I see that brand name, boom, I automatically think about their soft drinks. I see the golden arches, boom, I think about McDonald's hamburgers. Amazon, buy whatever I want and get it in 2 days, maybe 2 hours, depending on where you live. Samsung, personal consumer electronics. Microsoft, hardware and software. Google, search. Nike, shoes. Ford, trucks. So every single time you see or hear or experience a trademark, it should automatically call to mind a very specific set of products and services, because that is what a trademark does. It indicates the source of specific products and services, and it distinguishes them from the products and services of another party. The easiest way to think about that is to think about the last time that you went to a restaurant, you sat down, the waiter came over, said, "Can I bring you something to drink?" And you said, "Yes, I would love a Coke." And he says, "Is a Pepsi okay?" And that is a trademark in action. You are using the Coca-Cola trademark to indicate the source of the product that you want. The waiter is using the PepsiCo trademark to indicate the source of the product they actually provide. And both of those soft drink companies are using their own trademarks to indicate the source of their specific products. So think about yourself as a brand owner and think about what you are using to indicate the source of your specific products and services. Another way to think about a trademark is legal protection for your brand. Marketing folks will often talk about a brand as being how your consumers feel about you when they see your trademark or experience your product or walk into your store or your restaurant or they step up to your food truck. How do they feel about that experience? And that's great. A brand can be a wonderful thing, what you evoke in your customers. But the question is, how do you protect that feeling? That's very difficult to do. What's easier to do is to protect a piece of your brand through your trademark. And so a trademark is intellectual property, and it is something that you can enforce against people who might be infringing on your trademark. So we're going to talk about today are all aspects of trademarks. We're not going to talk about brands in general. We're going to talk about your trademark. So the indicator of source for your specific products or services. So now that we know what a trademark is, let's talk about what a trademark is not. A trademark does not mean that you legally own a word or a phrase. It does not mean that you can stop other people from saying that word or that phrase. And it does not mean that people owe you money if they say your word or your phrase. I've heard that before. Jason, if I trademark this, that means that anytime somebody says it, they owe me a nickel. No, that is not how it works. So let's think about Apple, for example. So Apple Incorporated has a federally registered trademark on the word Apple for their phones and watches and laptops and all that other stuff. Does that mean because they have a federal trademark registration that they own the word Apple? No, of course not. They don't own it. They can't stop me from saying the word Apple, and I certainly don't owe them money because I've said the word Apple. What they do have, however, is the exclusive right to use the word Apple to indicate the source of their specific products and services. So if I were to invent a new mobile phone, would I be able to refer to it as an Apple phone? No, because Apple Inc. has the exclusive right to use the word Apple to indicate the source of mobile phones. Okay, so oftentimes people think, oh, if I just say the word trademark after some cool phrase that I came up with, that means that I own the phrase and nobody else can use it or put it on a t-shirt. Nope, that is not what that means. A trademark is the indicator of source of specific products and services. If it isn't indicating the source of products and services, it is not a trademark. It's just a word or a cool phrase or a slogan or a saying or some sort of design or something like that. It is not actually functioning as a trademark until it indicates the source of goods and services. All right, now I have been saying goods and services. Let me just clarify this a little bit. So as you can see, a trademark indicates the source of products and service mark indicates the source of services. But honestly, folks, you don't really need to worry about the difference between the two of them. You can just refer to them as trademarks or even marks. And it's totally fine because the word trademark encompasses both source identification of products and services. If you want to get hyper technical, sure, cool, go for it. But don't think about it as a requirement. Don't get all twisted up about it. You can just refer to it as a trademark and it's totally fine. So let's talk about some of the most common source identifiers. These are what I think of as the big three when it comes to trademarks, and that is brand names, slogans, and logos. And probably most of you today, when you were thinking about, oh, I'm going to attend this webinar to learn about trademarks, these are probably the things that were coming to mind. If you're a business owner, you might be thinking about, well, let's see, I do have my logo, or I've got this cool saying that I use with my customers, or maybe it's my brand name. You were thinking about trademarks. And these are all the sorts of things that are often registered with our office. There's some other things I'm going to show you in just a second, but these are the major things that are often registered with our office. The first one, the biggest one, of course, is going to be a brand name. So as you can see down in the bottom left-hand corner there, that is the one of the registrations for Coca-Cola for their soft drinks and tonics and syrups for making, beverages and whatnot, amongst a whole lot of other different things that they're doing under their brand name of Coca-Cola. What I want to point out to you right there, though, is that's just the wording Coca-Cola. They have registered that wording just like that with our office. And you might look at that and you might think, Jason, that's weird. I never see Coca-Cola in Times New Roman font. It's usually in their fancy Spencerian font. You are correct. That's usually what you see. But what you see on the screen right there is the version or format that Coca-Cola used when they registered this wording with our office. And they did it for a very specific reason. What you see right there is what is referred to as standard character format. And essentially, what Coca-Cola is saying is, hey, USPTO, I want to register Coca-Cola with you for my various products, but I want protection for the wording itself, not necessarily for what it looks like. And we said, okay, that's fine. And what that means is, over the life of the trademark registration, Coca-Cola can use that wording in whatever font style, size, color they want to. And when they submit their evidence to us of how they're actually using it in interstate commerce, we're not going to say, whoa, 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 whoa. You registered it with us in this fancy cursive font, but over here you're using it in a bubble font. These don't match up. You're not showing us good use of how you registered it with us. We're not going to say that because when you register your trademark in standard character format, we don't necessarily care what font you're using it in. So this is giving Coca-Cola an incredibly broad scope of protection for their wording. And over the life of their registration, which could last over 100 years, it has already for Coca-Cola, they could start using it in whatever font style, size, or color they wanted to, and it's not necessarily going to make a difference when they submit their evidence to us. It may sound limiting, but registering and protecting just the wording alone, regardless of what it looks like, gives you an incredibly broad scope of protection for your trademark. Now, to be clear, Coca-Cola has also submitted registrations or applications to register Coca-Cola in Spencerian font and all sorts of other different things because they do also want protection for what it looks like. This is just one of the applications and registrations that they have with us. If you're asking, could I register a slogan or a tagline? The answer is yes. Yes, you can. For example, Coca-Cola has registered "It's the Real Thing." Over the years, they've also registered "Always Coca-Cola," "Open Happiness," "Have a Coke and a Smile." Think about all the other slogans that you might have seen out there. For example, "Just Do It," or "I'm loving it," or good. Right? There's all sorts of slogans or taglines that we hear, and when we hear them, we think, ah, yes, McDonald's, or whatever it happens to be. As you can see, Coca-Cola has also registered the phrase "It's the Real Thing" in standard character format, which again means that over the years they can put it in whatever font style, size, color they want to, and when they submit their evidence to us, we're not going to necessarily question what it looks like. So this is another option for you. And if you do have a logo that you want to protect, you do want to protect what your trademark looks like, sure, you could submit that in an application to us. You can see an example there of the Always Coca-Cola button. So it's protection for wording and a design combined together. Or maybe it's just a design alone, like the two-dimensional Coca-Cola bottle that you see right there. That's another option if your trademark doesn't have any words in it. That's fine. You could submit that too. So I want you to think about how you're actually using your trademark and also how you might be using it in the future. So sometimes new trademark owners and they're applying to register their trademark for the first time, they think that they have to submit some big full color logo because that's what they got from their graphic designer or what they designed themselves or whatever it happens to be. That's not actually true. You don't have to submit that full color version of your logo. Sometimes some folks are just going to submit the wording alone through that standard character format. Or if they do want to protect what the trademark looks like, they might submit an application for that logo, whether it's a stylization or a design or something like that. But they might do, well, like you can see on the screen there, and submit it not in color at all. And again, this is for a very specific reason. Much like the standard character trademark, when you submit your trademark in special form format without any color in it, what you're telling us is, hey, USPTO, I'm not claiming any color in my trademark. And we say, okay, that's fine. And so what that means is, again, over the life of the trademark registration, when you submit your evidence to us of how you're using it in interstate commerce, we're not going to question what color you happen to be using it in. So again, it's going to give you a broad scope of protection because over the years, you might decide to change up the colors that your trademark appears in when you put it on your packaging or on your labels or in the advertisements for your services. It is giving you flexibility because sometimes you don't want to be locked into colors for the next 5, 10, 15, 20, 30, 50, 100 years. Now, if you're Coca-Cola and other brands and things like that, where the color really does matter, you might also submit an application to register the full color version of your logo, but it's not a requirement. Or you might be somebody like Coca-Cola who submits multiple applications to our office to protect all sorts of different versions of the various trademarks that they use every single day. Do you need to do that as, for example, a small business owner? No. That's up to you. What you want to do, it depends on the choices that you want to make, how much money you have in that bank account that you want to put towards federal trademark registration. I will tell you right now, not legal advice, but I've worked with a lot of small business owners over the years and seen what they've submitted. And oftentimes, whether it's a small business owner or oftentimes the big guys too, what they submit, if they want to protect the wording itself, is the standard character format version, like you see on the left-hand side there. And in addition, they might submit another application to protect what their trademark looks like, but they might do it without any color in it so they can give themselves that flexibility. But again, the choice is always yours as the brand owner. So before we move on to something else, I want to open up your minds just a little bit more. So one of the amazing things about trademarks is that pretty much anything can be a trademark so long as it identifies source. It could be something like a sound, like the NBC chimes, bum, bum, bum. Or maybe, for example, it's the sound of a lion roaring before the beginning of an MGM Amazon movie. You hear that sound, you automatically know who is the provider of that particular movie. It could be a color. So the little brick-like thing you see down in the bottom left-hand corner there is one of our first color trademarks that we allowed to be registered at the office. You can't tell it, but that is a piece of fiberglass insulation in the color pink. And that is a federally registered trademark of Owens Corning. You see pink fiberglass insulation, that is a federally registered trademark. Maybe you're fortunate to have received jewelry in your lifetime and it came in a robin's egg blue box. Well, you know just by looking at that box that that came from Tiffany's. And that color when used on their boxes and on their bags is again a federally registered trademark of Tiffany's for their jewelry. Same thing is going to be true for UPS. You look outside, you see that brown panel truck or panel van, you see somebody hopping out in their brown uniform. That color brown, when used on their vehicles and on their uniforms, is again a federally registered trademark for their, parcel delivery services. But to be clear, does that mean that Owens Corning owns the color pink, or Tiffany's owns the color robin's egg blue, or UPS owns the color brown? No. Other people can use those colors as well, but they are the ones who have the exclusive right to use them to indicate the source of their specific products and services. The last thing that I'll say right here is take a peek down there in the bottom right-hand corner of your screen. You probably recognize who the provider of that particular product is just by looking at that bottle. Probably everybody on the call today says, yeah, that's a Coke bottle right there. That's right. So just by looking at the shape of something, sometimes the shape alone is an indicator of source. And that particular shape for Coca-Cola has been around for probably over 100 years at this point. When you see that contour bottle, you know it's a Coca-Cola, even if you're standing on the other side of the convenience store and you don't see any other signage. Think about the shape of a Volkswagen Beetle or the shape of a Weber grill. You see those, you automatically know who the provider of that particular product is. Now, I'm showing you all this stuff not because you have to have these things, but because I want you to think creatively about yourself and your business and the sorts of things that you might be using to indicate the source of your specific products and services. So again, think expansively, but don't feel like you have to have all of these things. All right. So we're going to go ahead and hit a knowledge check right now. So Ali, if you could go ahead and launch that very first poll, and we'll see how people do. Now, I'll tell you right now, I don't care how you do, okay? I just would like for you to make a guess, all right? Take a shot at it. Doesn't matter whether you get it right or wrong. All right, you probably know the answer to this already, and I'm already seeing the answers coming in here pretty fast. Does a federally registered trademark mean that you own a word or phrase? Yeah, that's right. You guys are hitting it. You're coming in pretty fast on those no's, and you are correct, my friends. Just because you have a federally registered trademark, it doesn't mean that you own that word or that phrase. What it means is you're the one who has the exclusive right to use that word or that phrase to indicate the source of those specific products and services. So great job on that one. Thank you very much for that. And Ali, I'm going to ask you to launch the second poll. And I'll tell you folks, this one you are potentially going to be making a guess on because I have not given you the answer so far. Okay, so think about this before you respond. And my guess is we're probably going to go 50-50 on it. But do you have to use your business name as your trademark? And I'm going to give you a second here to think about that because this is a question that we get a lot. Jason, I have my business name. What does that mean? Does it mean I have a trademark? Does it mean I have a federal trademark registration because I have a business name? And oh, wow. Oh my goodness, you guys really coming in hot here on these no's. I'm going to wait till it goes over 100. Yeah, there we go. Okay, there you go. That's the answer. The answer is no. You do not have to use your business name as your trademark. So sometimes we talk about these things and people get a little confused. I've had conversations with somebody who kept referring to their brand name as their business name. These are actually two completely different concepts. Your business name is just what you use to register with your state or jurisdiction in order to do business in that state. So the only people who really see your business name are going to be the clerk, right? The Secretary of State, or these days it's just going to be a computer somewhere and no one actually ever sees your business name except for maybe your accountant or whoever's filing your tax stuff at the end of the year. Your trademark, on the other hand, is completely different. So your trademark is going to be, which could be your brand name, for example, is what you use with members of the public to indicate the source of your products and services. To further complicate matters, those could be the same. So it is possible that your business name could also be your brand name or your trademark, but it doesn't have to be. If you use your business name as a trademark, sure, Fine, it could be, and that's potentially something that you could register with us, but it doesn't have to be. So I don't want you to fall in the trap of thinking that you have to use your business name as your trademark. Your business name, or your trade name, as it's sometimes called, your company name, your DBA, something like that. It could be the most boring thing in the world. Jason LLC. Fine. But what I use with members of the public to indicate the source of my products and services, maybe that's something super awesome. Okay, so they can be completely different things. Great job on that poll, guys. You did a fantastic job. So we're going to move on, and we're going to talk about the benefits of federal registration. So now that you know what a trademark is, why would you even think about registering it with the USPTO? So here in the United States, trademark rights are created in a couple of different ways. We're going to focus on two of those ways right here today. One of them is common law, and the other is federal registration. And if those words are like, I don't know, Jason, what do you mean by that? Don't worry, I'm going to walk you through it right now. So common law trademark rights are created as soon as you begin to use your trademark to indicate the source of your specific products and services. That's how it works in the United States. You have to be using your trademark in order to create rights in that trademark. That's not necessarily true in other countries where you're not required to use your trademark. Sometimes it's the first one to apply to register the trademark with that country's intellectual property office. But that's not how we do it here. Here we say that you have to be using your trademark in order to have rights in it. But that could be a great thing because you don't have to necessarily do much except for use your brand name, your slogan, your logo to indicate the source of your specific products and services, and already you're beginning to create rights in that trademark. Now, the issue is it's going to be limited to the geographic area in which you are operating. Now, I know there's a lot of you on today who are going to say, Jason, have you heard of the internet? Okay, it's not just one geographic area where I operate all over the place. Okay, I got you. I understand. I'm with you. But there may be folks who are just operating in a specific geographic area. And for illustration purposes, let's just assume that that is true. Okay, so your rights are only going to exist in the area in which you are operating. And for some of you, that might be fine. You might go the rest of your business life and be like, you know what? I'm just going to rely on my common law trademark rights. I don't care what happens outside of a X mile radius from where I'm operating. Doesn't matter to me. I'm good where I am. I've got my strong common law trademark rights and I'll enforce them in case somebody a town over wants to open up their own Bob's Muffler shop. I'll tell them, no, I've got common law rights. Get out of here, right? Or if you want to be a franchisee, you can pay me for the use of my trademark. Maybe. So the issue with common law trademark rights is that they are limited to this geographic area. These rights are mostly based upon state law. Most of the time it's going to be state statute, could be based on state common law. These days it's mostly going to be statutory law. And it's totally fine. What you can do as soon as you start using something as a trademark is go ahead and put a little TM next to it. Or if you want to be super fancy and you're a service provider, you could use an SM instead. TM for trademark, SM for service mark. But for those of you who've been with us from the very beginning of this presentation, you know that the word trademark encompasses both products and services. So TM is totally fine. There's nobody that you have to ask permission from in order to put a TM next to your unique trademark. There's no particular font you have to use, no particular size, no particular placement. Most of the time, you're going to see it on the right side of the trademark in either a superscript or maybe in a subscript, but it's really up to you. What you're doing when you're putting a TM next to your trademark is you're letting the public know, hey, back off. I am claiming this as my trademark. I am using it to indicate the source of my products and services, so don't infringe on it. So you're making sure that people are aware of your trademark rights, even if you don't actually have it registered somewhere. What you cannot do is use that R in the circle symbol. That is reserved for trademarks that have been federally registered with the USPTO. Now, here's the thing. You could go your entire business life and only rely on your common law trademark rights. You never, ever, ever have to register your trademark with us. It's your choice. There's no law, no regulation says that you must register with us. It's an optional thing that you can do if you want to. But just keep in mind, especially if you just have a small business and you're just going to be operating in your hometown and, that's it and that's fine. Hey, totally cool. You can rely on those common law trademark rights. But if you are someone who is operating across state lines or selling to folks in another country or providing services to folks in another country, you might be interested in federal registration because you want to expand your business and you want to make sure that you have protection for your trademark outside of a smaller geographic area because you're operating in an area larger than a small geographic area or just inside one state. So you might want to think about applying to federally register your trademark. And if you do, and you get to registration, you create all sorts of really great rights on what is known as the principal register. So when you register your trademark on the principal register, it creates a legal presumption that you are the owner of the trademark and that you have the right to use it throughout the entire United States and its territories. To be clear, it is creating a presumption of ownership and right to use. That doesn't exist under common law. There, you are going to have to be proving to the court, proving to the judge or to the jury, no, 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 I'm the owner, I've been using it longer, right? And the other guy's like, no, 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 I've been using it longer. Well, here, your certificate creates this presumption that you're the owner and have the right to use it. So it automatically puts the burden on the other guy for him to say, oh, okay, but no, 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 I should have stronger rights here. Right? So you're already putting them on the back foot. It is notice to the public of your rights in this trademark. You can bring legal action concerning your trademark in federal court. And this is one of the coolest features that not a whole lot of people know about, is that you can record your registration with U.S. Customs and Border Protection. And this is a great benefit if you are in an industry in which there are counterfeit goods that are flowing into our country. Most of the time, you're probably going to see it with your clothing, footwear, electronics, software, sporting goods, personal products. Think about, makeup and lotions and shampoos and things like that. It could be perfumes and cologne. It could be wine. It could be high-end luxury goods, jewelry. It could be your common everyday products. It could be just about anything. It could be aftermarket automobile parts, airplane parts. During the pandemic, it was personal protective equipment. If there's something that the folks outside of this country think that they can make a dollar on based upon a counterfeit good that they're shipping into our country, they're probably going to do it. So if you're in one of those industries and you're worried about a counterfeiter from outside trying to ship in products that are going to undercut you, what you can do is record your federal registration with CBP. And what you do is you record with them and you give the agents information about your trademark, things to look for, stuff like that. And that means that the agents are going to be working at our ports and borders to stop those infringing goods from entering. And you'll hear these news reports from time to time about these seizures that have been carried out by CBP. There's one recently out of Texas where they got about $200,000 worth of counterfeit tobacco products. There was one not too long ago that was counterfeit Pokemon and Hello Kitty stuffed animals that were coming to the country. There was, I forget it now if it was 3 million or 7 million worth of counterfeit Apple chargers that people were trying to bring into the country, ship into the country. And CBP seized those. So you can see there's a whole lot of value that is created by having our CBP agents stop those infringing goods from coming in, because obviously the street value of those things could be in the hundreds of thousands, millions of dollars. And especially if you're a small business who say all of a sudden becoming really, really popular, you're going to want to make sure that you can stop those folks from sending in those counterfeit goods, which are going to undercut you. And of course, there's the additional issue that counterfeit goods are often made in completely unsanitary conditions, especially if you're in personal products field. You have no idea what is ending up in those things. And people have been seriously injured because they used a counterfeit face cream that had battery acid in it, or all sorts of terrible things. If it's a counterfeit pharmaceutical, it might have fentanyl in it, right? You die within seconds of taking these things. So nobody wants their customers to be using counterfeit products. So CBP is a really cool benefit that you have access to, so long as you're registered on the principal register, so just something to keep in mind. Okay. Another great benefit is that you can try to extend your protection outside the United States into other countries. So you can use your registration here as a basis to extend protection abroad. Because there is no such thing as an international trademark registration, which all of a sudden gets you protection immediately around planet Earth. That does not happen. Trademark rights are territorial. They are country-based. So if you want protection in the US, you file in the US. You want protection in Canada, you file in Canada. Mexico, Mexico, and so on. So if you want protection in another country where you know you have customers, or you're going to be expanding into that country, or perhaps you're even manufacturing in that country and you want to make sure you can get your products out of that country after they're manufactured and not have your local business partner be the one who quickly registers your trademark in their country and prevents you from being able to ship your own products out of that country. So you might want to think about those things, and federal registration is a more efficient way to extend protection into other countries. And of course, the coolest thing of all is that you will no longer use the TM or the SM, but instead use the R in the circle symbol. And sometimes people ask, oh, Jason, do I just put the R in the circle next to the TM? And the answer is nope, no need. You can remove that TM and replace it with the R in the circle. Okay, so there you go. As you can see, I'm a huge fan of the benefits of federal registration, and I could talk about them for a very long time. If you have questions about it, feel free to pop those into the chat. Just a quick reminder, I'm not looking at the chat as we go through, but I'm going to take a peek when we get to the end of the presentation and then answer as many questions as I can at the end. All right, Ali, let's go ahead and launch poll number 3 there. I have already given the answer to this, so hopefully you guys were all paying attention. And the question is, are you required to register your trademark with the USPTO? Is there a law out there that says what you have to do, folks, is register your trademark with the USPTO? Look at all those no's coming in. Yeah, you guys were listening. You were paying attention. Thank you so much for that. And I appreciate you participating in the polls as well. Thank you, thank you, thank you. Yeah, you're absolutely right. You're not required to. Remember, you could go your entire business life just relying on your common law trademark rights. I sometimes like to refer to common law trademark rights as the cake. And cake on its own can be delicious. But what you really want sometimes is that icing, right? Is it a requirement to put icing on a cake? No, but it certainly is delicious, and it's a great way to enhance your rights. So awesome job on that one, folks. All right, Ali, since they're so good at that one, let's go ahead and launch poll number 4 here and see what people say. And again, I gave you the answer to this one too. So does registering your trademark with the USPTO give you international protection? Oh my goodness, look at all these really fast no's that are coming in here. Yeah, keep them coming. No, keep them coming. I love it. Keep them coming. You guys are absolutely correct. The answer is no. It does not give you international protection. Remember, trademark rights are territorial. They are country-based. But you can use it to try and extend protection into another country. All right, wonderful job on that one, folks. Great job. And again, thank you for participating. I love it. In the end, it doesn't matter to me if you say yes or no. I'm not going to think any less of you, depending on which way you go, but I do appreciate you getting it right. Okay, so let's dig into this topic right here, which is about selecting or choosing or creating a strong trademark. And we're going to be here for a little bit, okay? Because what we're going to talk about right now are 2 of the main reasons why trademarks are refused registration. So if you are just starting out in your business and you're trying to come up with what your trademark is going to be, this is a wonderful time to learn the things that I'm going to talk about right now. And even if you already have your trademark and you're considering federal registration, it's a great time for you to learn about this stuff too, because you might be able to say, oh, okay, maybe I need to rethink what I was going to do based upon this information. So this hopefully is going to be, look, I hope all of this is good takeaways for you folks, but hopefully you're going to find a lot of really great information here to help you make decisions about your trademark. So just a couple of things to remember. It is the mission of our agency to register trademarks. That is what we are here to do. We want to be able to register your trademark. The default answer is yes. However, not every trademark is registrable. And there are reasons why trademarks must be refused registration. And we're going to talk about those two main reasons here in just a couple of minutes. The other thing that I do want to highlight as well is that not every trademark or trademark registration is enforceable. And the first time I heard that, I was like, I don't understand what that means. How could that be? Somebody spends all of this time and effort to federally register a trademark. Are you telling me they can't enforce that? And the answer is correct, because of common law trademark rights. And if we have time here in a little bit, I can even tell you a little story about a well-known fast food brand that you know that was not able to enforce its federal rights in a 20-mile radius in Illinois. And that is because of stronger common law trademark rights. All right, so it's just something to be aware of. You want to make sure that your trademark is going to be both federally registrable and legally protectable. So these are the two main concepts which I think are going to hopefully help you along those lines. The main refusal that we often give is what is referred to as a likelihood of confusion refusal. And the other one is going to be based upon the strength or the distinctiveness of your trademark, which will manifest itself as this descriptiveness refusal. And if you're looking at those words and saying, Jason, I don't get it, don't worry. We're going to dive in, and by the end, you're going to have a good understanding of both of these concepts. You're going to come out of this sounding like a trademark expert. So let's talk about likelihood of confusion. So one of the main things that a trademark does is indicate source. If a trademark is confusing consumers about the source of a particular product or service, it is not doing its job. And it's bad policy and it's bad for everybody. If customers are confused, they don't know, am I buying from this brand that I know and trust, or is it this one over here? I'm not sure, I'm confused. And so what we want to do is avoid a situation in which someone applies and registers a trademark that is likely to cause confusion with a trademark that has already been registered with our office. And so what's going to happen is when you apply to register, the examining attorney who is assigned to your case is going to run all sorts of different tests on your application. And one of the things that she is going to do is she's going to look at your trademark and then look in our database. And she's going to look to see, when I compare this applicant's trademark to what we have in the database, is there a likelihood of confusion? And if the answer is yes, your trademark will be refused registration. Granted, you have an opportunity to argue against it, but it will be refused registration. If it's not likely to cause confusion, it won't be refused on that standard. So what is this test? What is it exactly that the examining attorney is looking at when she's looking at your trademark and looking at what's in the database? So it's a more complex test than this, but I'm going to boil it down to two prongs. She's going to ask the question, is your trademark confusingly similar to this one that I found in the database? And this doesn't mean, are they identical? It means, are they similar? Do they look alike? Do they sound alike? Have a similar meaning? Or maybe a similar commercial impression? That's confusing similarity. And it doesn't have to be all of those things. It could just be one of those things. It might be that they just kind of look alike, even if the way that they're pronounced is totally different or something like that, or the meaning is totally different. But if they look similar, that could be enough. Same thing if they just sound similar, phonetic equivalence, it could also be a problem. So assuming that's true, for example, assuming that your trademark is confusingly similar to somebody else's, the examining attorney is then going to ask the question, okay, Well, trademarks always indicate the source of products and services. So then she asks the question, are the goods and services provided under this trademark related to the goods and services provided under this other trademark? And if so, if both of these things are true, the trademarks are similar, and in addition, the goods and services are related, then she'll have to issue that refusal. If not, if one of those is a no, no refusal. So with regard to what we mean by relatedness, it's a little bit of a fuzzy concept, so bear with me. Think about what consumers are used to seeing in the marketplace when it comes to brands. Think about your own knowledge of brands and think about, do I typically see a company use the same brand on this product and also on this product? Are they producing both of those things? And if so, that's potentially relatedness. Like, for example, we're currently in baseball season. And so you might think about, does one company typically use the same trademark on baseballs as they do on baseball gloves or on baseball bats? If so, those could be considered to be related products, right? A baseball is not the same thing as a baseball glove, so the fact that they're different doesn't matter. The question is, are they related? Is peanut butter related to jelly? Yeah. And in fact, Smucker's still has registrations for Goober grape, where they're going to put grape jelly and peanut butter together in a jar. Yeah, you're going to eat those things together. So it could be related in that way as being complementary goods. But in the end, what's going to happen is the examining attorney is not going to base it on, what do I think? The examining attorney always bases it on evidence. So if the examining attorney finds evidence that companies use the same brand on this product and this product, or on this product and with this service, then she's going to have to issue that refusal. So again, a two-step process comparing the trademarks and in addition, looking at the relatedness of the goods and services. Let me give you some hypotheticals to make sure we really drive it home. So let's say that you apply to register Key Marquee as a brand name for shirts. You submit your application, the examining attorney gets it, she looks in our database and she finds, T Marquee is already registered as a brand name for pants. Clearly, that's going to be a problem. The T Marquee trademarks are obviously confusingly similar, and in addition, we know that shirts are related to pants. You and I could probably come up with right now 15 different brands that do both shirts and pants. And obviously the examining attorney is going to find plenty of evidence that the same brand is used on both shirts and on pants. So this one is a pretty straightforward example. There's going to be a refusal in this case. But let's switch it up a little bit. Let's say, for example, that you had applied to register T Marquee as a brand name for shirts, and the examining attorney found T Marquee was registered as a brand name for pants. Is this going to be a problem? And here too, the answer is yes, it is. So if we look at the trademarks themselves, T Marquee and T Marquee, you probably just heard it. They sound similar. In fact, they can be pronounced the same way. There is no correct pronunciation of a trademark, so both of them could be pronounced the same way. T Marquee. You hear it? Okay, that's phonetic equivalence. So we know the trademarks are confusingly similar, and we already know that shirts are related to pants, so here too, there would be a refusal. Let me change it up for you one more time. Let's say that you applied to register T Marquee as a brand name for shirts. The examining attorney finds in the database T Marquee has been registered for golf flags. Is this going to be a problem? Well, I have to tell you, I'm not sure. Okay, so is T Marquee similar to T Marquee? Yes, but the question is, are shirts related to golf flags? And I don't really know. If I was the examining attorney, I would have to do some really serious research in this case to determine whether there are brands out there that use the same trademark as a brand name for shirts that they do for golf flags. Or are there golf flag companies out there that use the same brand for their golf flags that they do for a line of shirts? I don't know. Maybe. Probably not, but I don't really know. We could also take a look and say, based upon the totality here, does Team Marquee have a different meaning when it comes to golf? So there's a deeper analysis that has to get done here. And I do this, and I want you to think about this because sometimes the answers are hard. There is no bright line rule that says this always means this. It really is going to boil down to multiple factors, and a lot of it has to do with the relatedness of the goods and services, and again, the similarity of the trademarks, right? So it's so important that you understand this stuff because you can do this analysis before you apply. And the reason that I want you to consider doing that strongly is because the last thing that I want or anyone at the USPTO wants is for you to apply to registered trademark, whereas if you would, and it gets refused, whereas if you had just done some searching beforehand, you would have discovered, oh, this probably isn't going to register because this guy is already there in front of me, confusingly similar trademark used with related goods and services. So that means I should really rethink this and come up with a different trademark, which is not likely to cause confusion. So how would you go about doing this thing called a clearance search? Well, at a very base, we recommend that you do two things at a very, very base level. One is, of course, look in our database of applied for and registered trademarks. The other thing that we would recommend is that you do some common law searching just by using the internet. Do some searches on your favorite search engine and just look to see what's out there. And remember, you're looking for people using a similar trademark with related goods and services. The fact that somebody has a business name doesn't necessarily mean anything because a business name is not necessarily a trademark. Or just because you see that somebody is already using a trademark in a different country, it doesn't necessarily potentially matter here because they're not necessarily using it in the United States, so it wouldn't be a block. Now, you might want to think about it and think about, that's a really big company overseas. I wonder if they're going to be moving into the US market. Is that going to be a problem for me? Could be, but it isn't always necessarily something that's going to block you from being able to use and eventually register that trademark in the United States. As I say, this is a very base level thing of what we recommend. We actually recommend that you conduct a comprehensive clearance search. And to do that, you're often going to want to hire a private US licensed trademark attorney to assist you. That person could look in our database, state databases, business name registries, just to look, foreign trademark databases, looking online, plus a whole bunch of other resources. It's a comprehensive clearance search to really clear the area and make sure that there's no one else out there who has the same or similar trademark being used with related goods and services. You don't want to step on their rights in the same way that you don't want anyone else to step on your rights. So we always recommend people do this. The other thing you might want to think about is don't just pin your hopes on one trademark. Sometimes marketing folks and trademark attorneys will say, hey, let's take a look at like 3 or 4 different options here. And so that trademark attorney can go away and do that search and come back and let you know, hey, this one probably is an 80%, it could go through. This one, 0%, no way it's going to go through. If you do this, you're going to get in a whole lot of legal hot water. I would advise against it. This one over here, maybe a 40% shot, and so forth. So you want to have some flexibility about your trademark and don't just lock in on one and say, oh my goodness, it has to be this. If it isn't, I don't want to go forward. Well, you could make that choice if you wanted to, but brands pivot all the time, right? They're always saying, hey, we could go this way, we could go that way. In some ways, it depends on whether it's a trademark that could actually register and then be enforceable. All right, so let me hit you with a knowledge check here. So Ali, if you could, launch poll number 5. So the question here is whether you think that there is going to be a likelihood of confusion in this case. All right, I don't see poll number 5 launching yet, but I'm sure it'll go soon. There we go. Is there a likelihood of confusion here? Okay, so let's say that you have your brand name of X seed for agricultural seeds. You do some searching in our database before you file, and you discover X seed registered for live plants. All right, I'm seeing a lot of answers coming in here already. You guys are running with it, and I love it. Okay, so I'm going to let you keep on answering. Well, I'll let you keep on answering. Okay. Some people told me sometime that I give the answer too quickly and they want longer to think about it. So I'm letting you do that. Well, it looks like we're over 100 here on the yeses. And you, my friends, are correct. In this case, there is likely to be confusion. So again, we do the analysis. Is X seed similar to X seed? Yes, they sound the same, even though they don't necessarily look alike. And so then we move on to the second part of the analysis. Are agricultural seeds related to live plants? It's not whether they're the same or identical, it's are they related? And the evidence is going to show us yes, agricultural seeds are related to live plants. So in this case, there will be a likelihood of confusion. All right. Excellent job on that one. Thank you very much, folks. And I'll tell you, to all the people who answered no to this one, uh, I used to give an answer here of like, I don't know, guys, I'm not sure. I'd have to do some research into seeds and live plants. But I'll tell you, I was doing this presentation one time in Kentucky, and there happened to be a lawyer who was in the room, and I showed this slide, and I heard, from the back of the room, and I talked to the lawyer afterwards, and it turned out he was the one who had argued this case, and he told me in no uncertain terms, yes, Jason, those products are related. All right, so this was a case before the Trademark Trial and Appeal Board. All right, so let's move on to the strength of your trademark. Okay, so we've talked about, is it likely to cause confusion with somebody else's? Well, this one, the strength of your trademark, this one is very much on you, okay? And your selection of your trademark and whether it is actually functioning as a trademark. Is it actually indicating source, or is it wording that merely describes what the goods and services are? Is it distinctive, or is it descriptive? That's what this boils down to. Let me give you a little graphic here, which will hopefully help. So as you can see on the screen, it's a temperature gauge that goes weak to strong or cold to hot. And what you can see there, those are parts of the distinctiveness spectrum, whether it's a generic term for the products and services, is it descriptive, is it suggestive, arbitrary, or fanciful? And obviously, you can probably guess you want to be on the strong part of this temperature gauge. So let's talk through this distinctiveness spectrum, and we're going to start down here at the bottom. So the generic term for your product or service is unregisterable. It is not a trademark if it is the name of the product or the service. You will not be able to register with our office if it is the generic term for that thing. An example here would be milk for a dairy-based beverage. It just tells you what the beverage is. It's milk. Okay, so think about, whether it's in cartoons or whether you sometimes see it in real life, that white box with a black lettering across it, oats. Rice. Okay, that's the generic term for the thing. For example, I have my coffee mug here. If I wanted to register a trademark for, I was the maker of I'm a ceramicist, say, and I'm making these mugs, and I want my brand name to be Mug. That's never going to happen, right? Because mug is the generic term for this thing itself. Not going to be able to register it with the USPTO. And it would be very impossible to enforce because it is the name of the thing. It's not actually a trademark. Okay, so as we move up that temperature gauge, we're going a little warmer, okay? So here it's a situation where it describes something about the good or the service. Technically, these are unregisterable on the principal register. And remember, the principal register is what you want to be on because it is what unlocks all of those sweet, sweet benefits that I was talking about earlier. And you cannot register a descriptive trademark on the principal register because it is not indicating source. The only thing that you can do with a descriptive trademark on the principal register is submit a claim of acquired distinctiveness, and then it might be registrable on the principal register because it's no longer descriptive, it's distinctive. And what that means is, yeah, sure, okay, USPTO. Yes, my wording does describe my products or services or something about them, but in the minds of my consumers, it's no longer descriptive. It is now distinctive. When they see it, they think of me. And so here, it's possible to register a descriptive trademark on the principal register, but you have to have that showing of acquired distinctiveness in order to do so. Here's an example of a descriptive trademark that did not register, Scoop, as a brand name for ice cream. Scoop is the descriptive term for a serving size of ice cream. In this case, the Trademark Trial and Appeal Board determined that it was merely descriptive and therefore not registrable as a brand name for ice cream. So if you register your trademark with acquired distinctiveness, you can get it on the principal register with that showing of acquired distinctiveness, but your scope of protection is going to be fairly limited. If you want a slightly broader scope of protection, you might consider a suggestive trademark, which suggests something about your product or service, but doesn't actually describe it. These are registrable. An example would be copper tone for suntan lotion. See, copper tone doesn't describe suntan lotion. It suggests that if you put the lotion on your skin and then go out into the sun, your skin might take on a coppery tone, but it doesn't describe suntan lotion. And here, you got a slightly larger scope of protection. But if you want a really large scope of protection, you might consider a trademark that is fanciful. So this is a made-up word. It has no meaning in English or in any other language, sometimes called a coined trademark. These are registrable at our office. They are inherently distinctive. An example would be Xerox for photocopiers, Pepsi for soft drinks, Kodak for cameras, Kleenex for facial tissues. These are just made up words. Now, we know what they mean because we have been experiencing these brands over many, many years, but they're just made up words. It gives them a huge, strong scope of protection. Same thing true with arbitrary trademarks. These are words that do have meaning, but that meaning has nothing to do with the underlying product or service. Again, these are registrable, inherently distinctive. An example would be Apple for computers. An apple, common everyday word, and as it refers to the fruit, but it's completely arbitrary when applied to computers and other pieces of technology. Another example would be BlackBerry for a mobile device, or Gap as a brand name for clothing. Again, it has wording that has meaning, but that meaning has nothing to do with the underlying product or service. Again, it's going to give you a broad scope of protection. And one of the things that we often talk about with fanciful and arbitrary trademarks and that wider scope of protection is, first of all, they're made up words. So it's unlikely that someone else is going to have a similar trademark to you. So that means when you apply to register, what are the odds of likelihood of confusion? Probably lower than if you have that smaller thing and it's just like a little bit descriptive or suggestive, right? Fanciful and arbitrary is probably going to lessen the chances of a likelihood of confusion refusal. It also means that if your competitors are like, oh, what a cool trademark, I'm going to do something kind of similar to my competitor, and they apply to register, they're probably more likely to get a likelihood of confusion refusal because you're going to have a broader scope of protection because you're the first one in there in the marketplace using this fanciful or arbitrary trademark to indicate the source of your products and services. And if you're sort of the first mover, the only one in there, the next person that comes in, if they do something that's kind of similar, they're going to be more likely to get that refusal rather than a situation where the marketplace is filled with all sorts of trademarks that are like kind of vaguely kind of the same and stuff like that. So, all right, Ali, let's hit them with knowledge check number 6. And so here's the question for you folks. Of these two trademarks, which one do you think is going to be registrable? Bicycle as a brand name for bicycles or bicycle as a brand name for playing cards? Yeah, these answers are coming in fast. And some of you are probably well aware of the particular brand name in this case. It has been around for over 100 years. That's right. Bicycle as a brand name for playing cards. If you want to get technical, it is arbitrary, right? It is a known word that has a meaning referring to the two-wheeled conveyance machine of some sort. But yeah, it's has nothing to do with playing cards, even though there's a bicycle that appears on the back of the playing cards. So in this case, bicycle would be registrable for as a brand name for playing cards. Bicycle for bicycles, that's a no-go. It's just the generic term for the thing. So great job as always on this, folks. You guys are doing an awesome job. We have 2 more poll questions to go. Okay. If you love them, hey, you only have 2. If you hate them, hey, you only have 2. All right. So let's talk about filing and registration here. So here's just a real quick breakdown of the process. It's obviously going to be a bit more complex than this, but this is kind of how it goes. You apply to register your trademark with us. We examine your application. If all goes well, it goes into this weird little phase called publication, and then hopefully from there, it moves on to registration. And this is not necessarily a fast process. The examination can take quite some time, but this is sort of how it works. You apply, we examine, goes to publication, and then on to registration. So as you can see, there is no such thing as like an automatic registration where you pay money and immediately get a certificate in return. That is not how it works. What you're paying for with your filing fee is the examination of the application to determine whether your trademark is registrable. If you do decide to apply to register, you'll be using something called Trademark Center. It is now the filing system that the form that you'll use is mobile friendly, has a guided user interface, draft save every 60 seconds, it's transparent costs so you can see what it's going to cost you, and it has prompts to complete commonly omitted information. The reason I'm highlighting these is because it's a new form, just been around since, well, the beta was last year, but it became official in January of 2025. And what we had for 20 years before that was none of these things. So we're very happy to have provided for you a modern way of filing where what you can take advantage of, and it's easier to do on your phone or your tablet, which wasn't the case in the other ones. And also the old version did not save until the very end, which people found very frustrating. If you do decide to apply, keep in mind there's multiple requirements. I'm just going to highlight a couple of them. One of them is that you have to tell us what your trademark is. Okay, obviously we have to know what it is that you want to apply to register. That's called your drawing or a representation or a depiction of your trademark. And as we discussed at the very beginning today, it could be a standard character format or it could be that special form format. So again, you're deciding, do I want to protect the wording alone or do I want to protect what my trademark looks like? You tell us, you either type in the wording you want to protect or you're going to upload the quote unquote drawing of your trademark. You also have to tell us what are the products and services that you're using with your trademark. You need to list those for us. There's a whole lot of things that go into goods and services. The one thing I would put out here is that you do not have to list every single thing that you are doing. It is up to you as the brand owner to make your choice. And if you're a small business owner, you don't have a whole lot of money to put towards federal trademark registration. You might just list the main things that you're doing and figure later on down the line, you'll submit a new application to register your trademark for these additional goods or services that you might be providing. You also have to give us the filing basis. So what's the legal reason that you have to be able to register your trademark for these particular products and services? It could be that you're already using your trademark in interstate commerce, or it could be that you're not using it yet, but you have a bona fide intent to do so within the next 3 to 4 years. Either one is fine. It's up to you, but just keep in mind if it's the intent to use basis, you will have to submit an additional filing later on, and that requires an additional filing fee and things like that. So again, it's up to you. There's benefits to going either way. We have to know how to contact you, and also you have to pay that filing fee. And if any of you are wondering how much it costs, the base fee is $350 per international class. Just so there's no confusion, international class is called that because we have agreements with other countries around the world that goods and services are split up and listed into 45 different classes, or sometimes people refer to them as categories. So for example, clothing happens to be in class 25, sporting goods are in class 28. So if you were applying to register Jason as a brand name for shirts and shorts, and also for baseballs, then that's going to be $350 for the things because they're in the clothing that's in class 25, and $350 for the baseballs that are in class 28. So the filing fee at this case would be $700. But again, it's up to you. If the main thing you're doing is baseballs and you don't want to worry about the shirts and the shorts, fine. You could submit your application. Jason is a brand name for baseballs. It's only going to cost you $350. So I know the international class makes things a little bit confusing because you're like, oh, is it for the whole category? Nope. Basically, it's just a way of dividing things up. But the cool thing is you're not paying by the product or service, you're paying by the class that they happen to be in. So it's a cost savings for you in many ways. That's the base filing fee. If you use the base fee and you use the listings of goods and services that we provide and you include all the information, That's going to be your filing fee. It can go up if you don't provide all the information. It'll be an extra $100 per international class. If you decide to draft your own listing of goods and services called freeform text, that's an additional $200 per international class. And if you write a really, really long one that is more than 1,000 characters in one class, it's going to be an additional $200 per 1,000 characters over that first 1,000 characters in that international class. So you can see your fee could go very, very high if you decide to customize this thing. We've already talked about some of the reasons for refusal, likelihood of confusion and mere descriptiveness. That's not all. There's additional reasons such as geographic descriptiveness, or your specimens of use don't actually show use, or you're using your trademark in an ornamental manner. It's way too much stuff to go into right now, but I want you to be aware there's additional reasons why trademarks could be refused. If you do get to registration and get that certificate, keep in mind it is up to you to enforce your trademark rights. There is no trademark police. We are not an enforcement agency. It is up to you as the brand owner to enforce your rights. So that might mean a cease and desist letter, or it might mean a lawsuit if someone is infringing on your rights. The one thing I would say that hopefully you're going to love is the fact that your trademark can last forever so long as you continue to file your post-registration maintenance documents with us. So unlike patents, which expire after a number of years, or copyrights, which expire over a number of years, trademarks don't necessarily. Your trademark itself can continue for a very long time, so long as you're continuing to use it. And your trademark registration can also continue for a long time, so long as you continue to use it in interstate commerce. You file the documents with us, and of course, pay those maintenance fees. So this is something that can last for a long time. You could pass it down as part of your business to your kids or your grandkids, to your great-grandkids. It's a piece of property, so you could actually sell it with your business. If you decide, you know what, I'm done, I'm going to go retire, I'm going to sell my business to somebody else, and your trademark could transfer along with it. Okay, here we go, Ali. Last two questions for the folks. Are you guaranteed registration of your trademark? Let's see what you say. My guess is you're going to quickly pile in with the correct answer on this. You guys have been crushing it all night long tonight. So let's see. Oh, yeah, coming in. I love it. Oh, my goodness. You guys are so good. So good. All right, keep it up. I'm going to wait till we get over 100. And there we are. Okay, good. You are correct. You are not guaranteed registration of your trademark. So here we go. If you could, Ali, close that one out. Move on to poll number 8. If it registers, do you have to do anything to keep your registration alive? Now, I just talked about this, so I'm sure that you're going to get this one correct. And yes, of course you are. Yes, you do have to do things to keep your registration alive. Continue to use it in interstate commerce, and file your post-registration maintenance documents with us. And I can talk about those post-registration documents if you want to. Maybe you've put a question in there or not. There's some that are required, some that are optional. One of the optional ones adds a really kind of cool benefit, which I can talk about. We have about 20 minutes or so, so hopefully I'll be able to answer that. So, okay, we're going to move on. Thank you, Ali. Thank you for that. And great job on the polls. You guys were hitting it hard all night long, and I really appreciate it. All right, so real quick here, how to find help. I just want you to be aware of the scammers that are out there. It's a problem. It's a real problem. And I want you to have your eyes wide open. So especially if you're new to trademarks and you're doing some internet searching, you're probably going to come across a lot of these folks. And they pop up at all sorts of points throughout the trademark application and registration process. They might pop up right now before you've even applied. You're typing in wording and you come across one of these non-attorney filing firms. And it turns out they're 100% a scam. Not all of them are, but some of them are, and they have a scam site that they set up, and then you think you're communicating with us, but you never are. You're just giving money to the scammer, and they're pretending to be us. They're imposters. So you want to be very careful. You're only working with uspto.gov. I'll show you stuff on our website. So just be aware. And once you do apply, you are all of a sudden going to hit, probably within 24 to 48 hours, with phone calls and texts and emails and stuff in your mailbox from scammers. And they're going to try to trick you and say, oh, no, you have to verify your business information, or you have to pay us $15 to attest to something in every state in the country. It's going to cost you an extra $2,700, plus there's this over here. None of that is true. Once you apply to register with us, your trademark is going to sit and it's going to wait to be assigned to an examining attorney probably in about 5 to 6 months. So all of that big flurry of activity that you're going to get after you apply, it is not coming from us. Okay, we're not going to immediately contact you and say, hey, you got to verify your information. We need your social security number. We need to have your credit card information over the phone. We need you to pay this money. Could you do it through a gift card? Could you give us a wire transfer? We need 4,000 euros to go to Lithuania for you. No, none of that is true, folks. That is not us. We are not doing that. Those are scams. So just be, please, please, please be very, very careful. Same thing with the solicitations you get in the mail. They're going to look like invoices. We will never send you an invoice. If there's something that you need to pay, we will let you know through an office action, and you'll be able to read that office action in our system. You'll have your own electronic case. You can go in and look at it, and you can see whether we're saying you need to pay money for this, that, or the other thing. If it's not in there, we're not asking for it. Okay, so just please, please be very careful. I'm not trying to scare you. I just want you to be aware and vigilant. Okay, in terms of resources, we have all sorts of great stuff on the website, uspto.gov. We have some videos, recordings of webinars and things like that. We also have our Trademark Basics Registration Toolkit. You see that QR code there on the screen. If you have another mobile device handy, please feel free to go ahead and scan that QR code, download the toolkit to your mobile device. It's a PDF. It's about 19 pages or so, filled with pretty pictures and all sorts of links to resources, and it kind of takes you chronologically through the process so you can understand it from beginning to end. We also have our Trademark Basics Bootcamp. Would love to have you come for that. It is totally free. It is totally virtual. It's 8 weeks. We run it 4 times a year. And again, we're taking you through the process. All the information you're hearing today, that's like the first module of Bootcamp. Then we talk about what the process is like. We do searching. We talk about the application. I walk you through the form. In one of the weeks, we talk about how to respond to an office action. We talk about all the things you do to keep your registration alive. And then the final week is an open-ended 90-minute Q&A where I've brought along experts and you can ask your questions and we will answer as much as we can in 90 minutes. I'd encourage you to sign up for this. Our next cycle begins on July 1st of 2025. So please join us for that. We'd love to have you come. Lots of other great resources available on the site. If you're not sure about a copyright, a patent, a trademark, a trade secret, what is it that you have, go ahead and scan that QR code. That'll take you to our IP identifier. It's a great way for you to answer some really basic questions to sort of figure that out. And then there's more advanced questions that come after that, as well as some tips on managing your intellectual property assets. If you have questions, we typically recommend you reach out to the Trademark Assistance Center. They're, as you can see, our main support center for trademark customers. I will warn you right now that they are very short-staffed, and so wait times are way longer than they typically are. That used to be 20 seconds you could give a call and you would be talking to one of our reps. These days, however, it's half an hour, sometimes an hour-long wait. Sometimes they'll have the automatic callback thing turned on. This is where we are right now. They are wonderful folks. They are doing their absolute best to answer every question that they can, but they're very overwhelmed and they can't get to everybody. Their office hours right now are 9 a.m. to 4 p.m. Eastern, Monday through Friday, and they would love to help you out, but just please be patient with them and just be aware. There's a lot of calls and emails coming in, and they're going to do their best. Also keep in mind that they cannot provide legal advice. I can't provide it either. Ali can't either. No one at the USPTO can provide you with legal advice. We also can't enforce legal rights or recommend specific private attorneys. Okay, so we're going to get to questions right now. So let's see. I am going to open up the chat and see what we had come in. All right, and I'm looking at the clock. Okay, we have 13 minutes. So I'm going to do my absolute best to answer as many as I can in 13 minutes. Oh my goodness, there's a lot in here. You guys, okay. Let's see. Okay, a lot of this about this. Dun, 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 dun. Oh, about music. Okay. Oh, a lot about music. Okay. A lot about music, a lot about audio. Kurt, for the logos. It says, are they to use the trademark or the Circle C or the Circle R? Remember, for logos, those are trademarks. So for common law, it would be, if you were the owner of that trademark, that logo, you would use the TM to indicate the source right, to let people know it's a common law trademark, or the circle R once you've registered it. Circle C refers to copyrights. And so copyrights are protection for original artistic works, and you can use the circle C as soon as you have you've created something that is copyrightable. Okay, so a lot of times it's going to be songs, movies, books, things like that. Websites are also copyrightable. As soon as you've affixed your original artistic idea in a tangible medium, you technically have a copyright under federal law. If you want to also federally register your copyright, you could do that, and that's with the U.S. Copyright Office. Okay, lots more audio things. Okay, I'm glad, Ali, hopefully you got that sorted out for people. Jackie, if the logo is submitted in all black, that would allow the owner of the trademark to use different colors for that logo over time. Yes, my friend, that is right. When you submit your trademark drawing without any color in it, it's going to give you flexibility over the life of the trademark registration, and you can sort of be using it in whatever colors you want to, and we're not necessarily going to question it. And I say most likely not going to question it. There may be times where color really does matter. So if you think about a drop, okay, the design of a drop, and it's for blood bank purposes or something like that, probably the color red is going to be pretty important there. If it's water related, the color blue might be. So maybe that's going to play into it. I don't really know. You know, same thing with sort of like Swiss cross sort of thing. Is it a red cross? Okay, that's going to be a problem. So you just got to have to be careful there with some of those colors. But for the most part, that's right. It's going to give you lots of flexibility. Okay, Cindy, if you wanted to register a slogan or a tagline, let me come back to quote. The first three words are always a registered trademark used in a broader way. Okay, like I love you, trademark forever. Yeah, so again, without providing legal advice, Cindy, if the three words are already a registered trademark, that could be a problem because you cannot use the registered trademark of someone else. But there are lots of circumstances where wording is part of a registered trademark, but it isn't actually the full trademark itself. This is going to get confusing. Something like I love you, as you've noted here in your example, that oftentimes is probably going to be considered non-source indicating because it is a common everyday phrase. So if the whole trademark was I love you, a lot of times that might be refused registration. There was a case where it was a bracelet and the mark was essentially the configuration of the bracelet that said I love you. Well, that's in some ways either ornamental or a commonly used phrase. I forget which the basis was for that refusal, but it's something that's not really functioning as a trademark. So quickly, if you're using the trademark of somebody else in your own thing, if you were going to say McDonald's forever and you were coming up with your own burger stand, probably not going to work. But if it was, I don't know, something, I don't know, it's a terrible example. I'm sorry, Cindy. Be careful. Okay, that's all I'm going to say. Be careful. If it is somebody else's registered trademark that you're incorporating into your own, that could be a problem. But as always, it's going to be fact dependent. Dorothy, nope, not Dorothy, DJ. It was my understanding that Harley Davidson was unable to register their engine sound. Why is that? Okay, yeah, it's a great question. So I don't know if they've been, yes, that was my recollection as well. They applied to register the sound of their V-twin engine. And the issue was that the board or the court found it was not distinctive enough where a person would hear it and they would automatically know that it was a Harley. Now, you might have your own opinion about that and say, clearly the judges don't ride. Anybody who rides knows the sound of a Harley. Hey, I don't know. They might have come back and tried again. I'm not actually sure. It was several years ago where that case was going through. But that's an excellent example where sometimes a sound or something like that, a sort of non-traditional trademark, it can function, but sometimes it doesn't. And it sort of is always going to depend on the facts in the case. Good question. Oh, Roberta, can your business name be stolen without a trademark? Not quite sure what you mean. Remember, business name is just what you use with your state, and it's quite possible that there are all sorts of the same business name is used by 50 different companies across 50 different states. That's not really stealing because they're just kind of using it, okay? Just remember, a business name is different than a trademark. A trademark is what you use with your public to indicate the source of your goods and services. Anise, some advice about, you've heard advice about getting an LLC in your name and then branching multiple products from that. Again, can't give legal advice here, but one of the reasons that companies or brand owners do form LLCs is because they want to limit their liability. Right, LLC, limited liability company. And that means the ownership of the trademark would be in that LLC. So that means if, for example, you were sued for trademark infringement, and so what would happen is you would not be sued as a person, your business would be sued. So you would be limiting your personal liability and putting the liability on the company itself. And if the company goes out of business, goes bankrupt, okay, but it's not affecting you personally or your personal bankruptcy or something like that. So yeah, that's oftentimes why people do form companies. They want to limit the liability to themselves and put all the liability, potential liability, on the company. So it's certainly something to think about. Let's see, Empress. Ooh, somebody has a registered trademark that you love, but they are not using it in commerce. Can I challenge this and gain the rights to use it? Ooh, okay. So Empress, just real quick. We don't determine whether you have the right to use a trademark. We only determine whether you have the right to register a trademark. So that's something to keep in mind. Okay, so you can always use something as a trademark, your choice if you want to apply to register it with us. So with regard to somebody having a registered trademark, but they're not using it, that is a problem. Yes. And there are actually a couple of proceedings that you could take advantage of. One is called expungement. The other is called re-examination. And those are for trademarks that have either never been used in commerce or were not in use in commerce as the date of different filing. This is all stuff that's under the what's known as the Trademark Modernization Act. And so this is a proceeding you could submit and say for either expungement or reexamination, depending on the facts. And you could say, hey, USPTO, this thing's got to get out of here, okay? Because it has never been used in commerce. Here's some negative evidence. I can show you that it was not being used at this particular time period and stuff like that. And so you could put that before the office, and the office will then take a look at that and determine whether or not it should still be registered. And if it shouldn't be registered, boom, it's going to get out of there. So that's an option for you. Great question. Love it. So Jackie, TM indicates common law trademark rights. Yes, absolutely. Consuela, what if you're operating on the internet? Yeah, great question. If you're operating on the internet and you are selling things to folks in other states or other countries or territories or whatever, or if you're providing services to people who are in those other places, that would typically be considered interstate commerce, and that might qualify you for federal trademark registration because you're not just using it intrastate, you're using it interstate. Let's see, Juvenito, what are the advantages, disadvantages to trademark at the state level and the federal level? Excellent question. So we don't have anything to do with state level trademark registration. You can do it if you want to, but just keep in mind that's just protection in that state. So that would be the advantage, protection in the state. Disadvantage, it's only protection in that state. And so there might be a situation where somebody else has rights in other states. And so the beauty of federal registration is that it's going to create that presumption of ownership and right to use throughout the entire United States. So let's say you're based in Texas, it's going to give you that presumption in the state of Washington, even though you're not using it there yet. So if you register and then someone comes along later, you can say, whoa, sorry, already registered here, get out. Okay, that's a great question. Does common law trademark protection go into effect during waitlist signups for service or only after payment is exchanged? Ooh, interesting. Yeah, Jenny, that's a really good question. Again, can't give legal advice here, but typically you have to be actually using it for the service you're providing and not just advertising for it. So like a wait list or hey, coming soon, that's not really trademark use until you're actually using it to provide, you're providing an activity for somebody else. So really good question. Again, can't give legal advice, but it's typically once you actually start doing the thing. Whether or not payment is exchanged doesn't matter. Sometimes there are free services. So think about your 501c3s or your charitable organizations. They might be providing a service without an exchange of payment. Totally fine. But still, it's an activity being performed for somebody else. But the general question that you're asking is correct. You need to actually be providing the service before its actual use. Great. Let's see, Cindy. Yep. Okay, I already answered that one. Already had the one from Empress. Loria, am I saying that right? Does trademark or the TM need to be shown by the trademark during the application process? No, it does not. Please do not include a TM on your trademark drawing. Technically, the TM is not part of the trademark, so we don't need to see it, and it shouldn't be in there. So great question though. And actually, in your evidence of how you're actually using it, if you want to have it on there, cool. Like you take a photograph of the trademark appearing on the products that you have. If it have a TM on there, fine. If you don't have a TM on there, fine. Doesn't really matter. It's really up to you. Great question. Siobhan, interested in learning if there's a course, website training that teaches business owners the foundation of searching federal trademarks before registering. Ooh, yeah. We have all sorts of great stuff on the site itself. I typically I do a live one at least once a month. Should have one coming up towards the end of June. I want to say June 20th. I think that's right, June 20th. You're more than welcome to sign up for that. We also have recordings of that exact same thing if you don't want to wait until June 20th. So that's the searching overview. And there are also 3 additional videos that we have up as well. You'll find those on the search page. There's like a search training page. Great. A good question. Thank you for that one, Siobhan. And also, if you take boot camp, I show you some searching stuff as well. David, do you have to record your trademark with CBP? No, you do not. It is your choice. It is up to you if you want to do it or not. Clarence, what's the cost? How long is the process? $350 is the base filing fee. It can go up from there, as I noted. How long is the process? It really depends on the facts in your case. Average 12 to 18 months, but it can go faster. I've seen it go faster. Actually, there's a couple that look like they went through in 3 months. That's wild. I've never really seen that before. Those were perfect, and I don't know how it happened. But other ones are typically going to take about a year, maybe a little bit longer. And just remember, Clarence, there is no guarantee of registration. So I had cases when I was an examining attorney that were lasting for years, 5 years. I had one that was like 10 years old when it popped into my docket. It can take a long time. So just be aware, it's always fact specific. Stephen, if you're using a common law trademark in a local geographic area, can you lose the right to it if someone else registers the same trademark with intent to use throughout the U.S.? No. As the common law trademark owner, you would have stronger rights. You at that point you could enforce them against the person once they okay. First of all, you can't register with intent to use. You have to register based on use. So that person, they would have to be using it before they get to registration. But there's certainly a very strong example of Burger King where there was a common law user of Burger King in Illinois, and they were able to stop Burger King, that we all know and love, from being able to operate in a 20-mile radius of their restaurant because they were the common law rights owner, even though Burger King had federally registered it for pretty much everywhere else in the United States. So great question, Stephen. Arthur Reese, how or where on the USPTO can the public find it when a trademark app has been filed so a person can impose it? You can look in our database. That's use the trademark search system to look in there to see. Or there's also the electronic official gazette called the EOG. You can look in there as well in order to oppose. Good question. Manaz, tagline which I did not register, but it was used as advertising. It's been adopted by others. And am I able to contest this with the USPTO? Ooh, good question. Adopted by others. So if other people are using it, again, that's not something that we handle. We just determine whether you have the right to register it, not whether you have the right to use it. So if these other folks are just are using it out there, it would be up to you to potentially cease and desist letter or sue them and try to prove that you had a stronger common law rights. Dave, USPTO is a federal agency, so how is a trademark registration through the USPTO not a federal registration? It is. So sorry if I misspoke. Yeah, it's a federal registration. And Manav's tagline is from 2002. I only discovered it recently. Yeah, so that would be something where you would have to figure that out in the courts or something like that. Dale, request a copy of this lecture. If you could, just go ahead and Ali, if you haven't already, could you pop the link to the slide deck into the chat so Dale can download it right now, doesn't have to wait for an email to come in. Jackie, the source of the trademark is in different industries but have the same name. One in food, one in automotive. Yeah, great example, Jackie. Yeah, those things can coexist. One of the more famous examples is Dove as a trademark. Dove registered as a brand name for soap, also as a brand name for chocolate or for ice cream. Totally fine for them to coexist so long as those goods and services are not related. Okay. Thank you, Dave, for your thoughts on the golf flags. Good, cool. Roberta, okay, I see we're 3 minutes over, Ali. I know. Let me just see what I can get through here. Okay. For related goods and services, does any brand sell the two products together under the same trademark? Rosalie, yeah, so it's going to be evidence-based. If it's just like one company that's doing it, that's probably not going to be dispositive. The examining attorney is going to want to find multiple things, so maybe not just one, but it kind of depends. Juvenito, if the trademark is T-Marky shirts, right, so we kind of covered that one for T-Marky. Krista, Krista, so similarity or relatedness really mean a company doesn't have to file a registration for similar products like shirts, socks, pants. They'd have to apply, right. Yeah, so good question there, Krista. That kind of goes to the relatedness factor. If you register T-Marky as a brand name for shirts, it's probably going to block T-Marky as a brand name for pants, shoes, socks, aprons, whatever, right? So you're absolutely right. So the question is, do you want to take that chance? Or do you want to register it for the things that you're actually doing? So it's creating a sort of zone around your trademark, but you don't, again, you're never required to register for all those things. So Anne, if a person wants to open a t-shirt business with different phrases written on them, are you saying it's best to have a standard character format logo and then use the logo for the t-shirt business? Ooh, okay, Anne. Okay, I am not saying anything because I cannot provide legal advice. I will say, please be very, very careful about phrases that you're putting on t-shirts. Oftentimes, a phrase that is put across the front of a t-shirt is going to be refused registration as being ornamental or decorative because it is not being used as a trademark to indicate the source of specific products and services, especially if it's a common phrase that's well known. So there's decorativeness, which is a refusal, common phrase, which is a refusal. So just be very, very aware. If it's a phrase, then you would need to be using it literally as a trademark, as a brand name. We often think about brand names being on the label, maybe on a hang tag, on the packaging for the goods, and things like that. And so to be very careful about that. And so with regard to wording, standard character format is what a lot of people use. Logo is a special form if you want to protect what it looks like. Okay, Gloria. Oh my goodness, we're 5 minutes over. I'm sorry, Ali. I'm going to go super fast. Doesn't the Apple trademark fail to indicate the source of goods and services? I'm not sure why where that one's coming from, Gloria. Apple does indicate the source of products and services. Right, Raina, Apple and BlackBerry didn't cause an issue. Interesting question. Probably not, because they're different sorts of fruit, so the commercial impression would be different. What if, Joe, what if your potential trademark has already been used, but company's no longer in business? Yeah, so if a trademark is no longer in use in commerce, then that might not be an issue for you. And if it is that business had a registration, but the registration has died or the application is dead, that also means that it wouldn't necessarily be cited against you. So it's possible, but just make sure to do your research. Nargwes, if a trademark is refused and approved and registers, how long does it last? We talked about that. Essentially, registration lasts 10 years, but you have to file every 10 years, and then there's a weird one between 5 and 6 that you have to do. Aisha, what do I select on the application if I want to register a logo but don't want to use color? So that would be a special form, and then you would select no color. Loriah, is a business license acceptable to show use of a trademark? No, it is not. We need to show it like on the goods themselves or in the advertising or providing of the services. Brittany, what are post-registration documents? There's a whole thing about that. Your Section 8s, combined Section 8 and 9, maybe Section 15. Feel free to check out some of the information on the website for keeping your registration alive. Okay, guys, we are 7 minutes over, and I feel like these are still coming in. There's no way I'm going to be able to get to all of them. So thank you all for being here. We're 7 minutes over. I do appreciate you being here. I did my best to get to as many questions as I could. So thanks for sticking with. I hope you all have a great night. Thank you very much for being here. And please take advantage of all the free resources that we have available on the site, and make sure to download a copy of the slides. You'll find the links to resources in there as well. So thank you all so much. Appreciate it. Take care.